very good afternoon, one and all, as we reconvene this 51st meeting of our Joint Select Committee on National Security. We welcome those of you representing the organizations that we invited, each and every one of you. That is to say, the Public Service Commission, the Service Commission's Department, and the Prison Officers Association. Let me invite you in that order to introduce yourselves for the public record and, of course, for the benefit of the members of this committee. Please.
Thank you, Mr. Chairman. I am Maureen Manchuk, Chairman of the Public Service Commission.
Good afternoon, everyone. I am Mrs. Parvati Anmol Singh Mahabir, Deputy Chairman, Public Service Commission.
Good afternoon, everyone. My name is Corey Harrison, Deputy Director, Personnel Administration, Service Commissions Department.
Thank you.
Good afternoon. Martel Waldron, Acting Deputy Director of Personnel Administration, Service Commission.
Good afternoon. Ms. Alison Douglas, Acting Legal Advisor, Service Commissions Department.
Good afternoon, everyone. Seven Richards, President, Prison Officers Association of Trinidad.
Good afternoon, everyone. Wendell Mitchell, Industrial Relations Officer, Prisons Officers Association.
Good afternoon. My name is Lester Walcott. I am the General Secretary of the Prison Officers Association.
Thank you very much, ladies and gentlemen, and let me invite my colleagues, members of this committee, to introduce themselves to you.
Good afternoon, everyone. Saddam Hussein, Member, Opposition Senator.
Good afternoon, everyone. Paul Richards, Vice Chair, Member.
Good afternoon, everyone. Nigel Freitas, Member.
And I am Fitzgerald Ethelbert Hines, Chairman of this committee, and we are all ably supported by the clerk of this committee, the assistant clerk, Madam Jackie Sampson Miguel, Mr. Brian Caesar, and other professional and very skilled persons who support the work of this committee. Thank you all very much for your presence. Let me indicate that this hearing is being broadcast on Channel 11, the Parliament channel that is, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. The objective of this stakeholder engagement, important and integral to this process as you are, is twofold. One, to determine the status of the investigations arising out of the prison break of 2015, July 24th, 2015. And secondly, to determine the status of the recommendations emanating from the fourth report of this Joint Select Committee on National Security concerning prison security more generally. You will recall that there was this very eventful occurrence on July the 24th, 2015, where 4 remanded inmates escaped from the Port of Spain prison. Very unfortunately, the events which ensued resulted in the deaths of 3 persons, 1 dutiful, hard-working police officer, and 2 escaped inmates not too far from the prison, and the wounding of 2 prison officers. To add to the seriousness of those circumstances, it became clear from the reports that arms and ammunition including, as defined in the Firearms Act, prohibited weapon, that is to say a hand grenade, was used in the course of this escape, and not by law enforcement, but by the escaping inmates. During the first session of the 11th Parliament, this Joint Select Committee conducted an inquiry which examined the status of the investigation of the Port of Spain prison break of that day and prison security. We, on the responsibility that falls to us as a committee, issued a report to the Parliament outlining our findings and our recommendations. Because as you would imagine, we are a small subset of the larger Parliament, mandated to look into these matters and to report to the larger Parliament in terms. A primary recommendation of that committee, this committee, was that the Public Service Commission treat as a priority the completion of the disciplinary proceedings arising out of the investigation of the events surrounding that prison break. Given that by the time we were issuing that report with those recommendations, it was a long way past July the 24th, 2015, as a matter of fact. That was dated, our report was dated, someone help me, let me get the exact date. Please bear with me, I just want to get the exact date we issued this report. Sometime in 2016, sometime in May of 2016, we made certain recommendations. In response to those recommendations, May the 25th, 2018, we requested an update of the status of these disciplinary proceedings. And the Director of Personnel Administration, by letter dated June the 13th, 2018, provided the following responses, which I want to bear on the record today. One, that the hearing of the evidence in the Port of Spain prison break on July the 24th, 2015, would be completed by November 2018, subject to the availability of defense attorneys. And two, that the number of disciplinary matters before the 4 disciplinary tribunals established by that department were 179 at that time. So we got a commitment that it would be completed by November 2013 with a caveat that 18, with a caveat that there were 179 matters. But we were told this would be treated with priority. In the meantime, persons, members of the prison service, who were on suspension, put on suspension from duty, whether with pay or on half pay, but suspended from duty, were keenly awaiting their day in court, if I may use that construction loosely. And their representative body, the Prison Service Association, the Prison Officers Association, led by Mr. Seren Richards, had been very vociferous in the public domain, calling for a resolution of this. And I would have heard him on occasions suggesting that some organization or organizations would have been at fault. I hope from the record I have just read, immediately it would have become clear that it would not have been this Joint Select Committee, because we had been pressing the service commissions and the Office of the DPA to bring resolution to this, as the record I just read showed. Since then, to compound matters, and we are looking at the general issue of prison security. It was a prison security issue that led to the disciplinary proceedings that are at the feet of the Service Commission, yet unresolved. And in the meantime, to compound the issue, we have had more breaches of prison security, while this one of 2015 remains to that extent unresolved. We have a deep and serious and genuine concern, hence the reason why we have asked you to come today and to put some questions to you, Service Commission, DPA, as to why these matters, to this day in 2019, remain unresolved, to the obvious and justifiable chagrin of the Prison Association, who speaks and looks out for the interests of its members, and more particularly, the members themselves, who say what you want. They are up to suspicion and to question once they were suspended from work, and they are not now allowed to carry out their normal duties. They want to have this matter resolved. And most poignantly, the public of Trinidad and Tobago, who deserves to have a resolution to these issues, at the very least, 4 years later. So I would like to open the floor to my colleagues, beginning with Senator Richards, who will request information from you, frankly, as to why we are in this position of stasis to this very day in this very important matter. Senator Richards.
Thank you, Chairman. Good afternoon again, everyone. And let me start, because there's a lot to get through today, with the Public Service Commission. Can you give us a status on this situation, which, according to what the chairman read into the record, should have had some level of closure, or the report or the proceedings made some progress and reported on 1 year ago in November of 2018?
I appreciate the opportunity to come before you to apprise you of the status of the 2014 prison break hearings and to clarify the manner in which tribunals operate. I am just as disappointed and frustrated at the seemingly slow pace such that these hearings have not been concluded. As you may be aware from the last JSC meeting, and indeed the chair said that we had indicated that we would have had some sort of resolution by November of last year. The three-member panel tribunals are part-time, and this in itself is one of the many contributors of the inherent delays in tribunal hearings. Nevertheless, we recognize this as a priority. The tribunal in question has been meeting as regularly as it could to bring matters to an end expeditiously. And to this end, what I am made to understand, one of the cases should come before us on or before the 9th of December. Should come before the report should be before us. The other case, on the 21st of this month, there's going to be a hearing on a no-case submission, and depending on the outcome of that, we may or may not have a report before the commission by the end of the year. And the third case, two witnesses still have to appear, and that should be tied up early in the new year. That's an account of what I have.
Thank you, Mrs. Manchuk. You mentioned that the tribunal was part-time, which was one of the bits of information given upon our last meeting on this matter. But there was also an undertaking given to ensure that the tribunal met more often because this issue was prioritized. How many times did the tribunal meet since that time in furtherance of your prioritization of this critical issue?
What I have before me, and maybe one of the members could be able to answer. What I have before me is between the time of this tribunal that started in 17, 89 meetings were held. But as to what happened between November, the figures for between November and now, maybe Mr. Warren can help us with that.
In hearings, meetings and hearings of the tribunal, was it in relation to this particular matter or generally?
It is in relation to this particular matter because this is a serious issue and it is of concern to the Commission. And from January 2017, when this tribunal, the present tribunal, was constituted, we brought them before the Commission and indicated to them the importance of having this matter concluded as soon as possible because of the very nature of the issue. What happened between 2017 and 2018, it took a whole year with to-in and fro-in between the claimant, the prosecution, the defendants, and legal advice with respect to the charges. That took a whole year. So in reality, it really didn't start until around mid-2018.
All right.
And we have been they have been submitting 6 monthly reports to the Commission, and in between that, we have been checking out to find out how regular they have been meeting. The issue, one of the issues is that we are the lowest in the ladder. The attorneys always give priority to matters in the Court of Appeal or the High Court or the Magistracy. We are the last. So invariably, you do have quite a bit of adjournments. Nevertheless, they have been meeting very regularly, and we should see a conclusion to this hopefully by the end of this year. And maybe
in summation, and for the benefit of the listening and viewing public, it is correct to say, and if I'm not, you will so tell me, before I allow Mr. Richards to continue, 3 prison officers are before you in these disciplinary proceedings. Is that correct?
yes, it is.
1 year or thereabout was spent in legal arguments between counsel for both sides.
Yes, that
preparing for the actual hearings. Is that correct?
That is correct.
Those would have gotten going about a year later, a year after it came to the Service Commission. Am I correct? The actual hearings.
For the tribunal.
For the tribunal.
Yeah.
Right. And you are saying that the Service Commissions called in the particular tribunal and told them that you wanted it treated as a priority for the reasons you have stated.
That's correct.
And you are saying that in the 3 matters flowing from that, 1 matter is on the 21st of December, is it? On the,
1 matter.
yes.
A report should be submitted to us on or before the 9th of December.
Meaning that the process has been undergone and a formal written report will now be presented to you.
For our decision, right.
The other matter?
The other matter, on the 21st of November, as I understand it, a no-case submission
was made, and a ruling
would be made. 21st of
will
November,
be made.
right?
Okay.
And depending on the outcome of that,
yes,
we may or may not have a report by the end of the year.
Okay, so the prosecution, so to speak, the prosecution would have put the case to the officer and his attorneys. They would have made a no-case submission saying, we have no case to answer on legal principles, and it will be answered, or they'll make it on the 21st. Please clarify that for the public.
Chair, I think we had to recognize too, this, what it is the chairman have been speaking, was reports that is coming from the tribunal to the commission.
Yes.
Right? We must understand the clear distinction between the work of the tribunal and
the
adjudication of the commission.
We do.
Right.
So I just wanted to get final clarity. On the 21st, the no-case submission will be made, or the result of it will be made known.
Chair, the ruling on the
No case submission will be delivered on that day.
Yes.
Right. So the lawyers for the officer who is being disciplined would have made a no case submission, and the tribunal will deliver its findings on whether it stands or whether it falls. And if it stands, then they'll proceed. If the no case submission succeeds, you'll get a report that the matter is at an end. If it does not succeed, then further proceedings will ensue. And tell me now in finality about the third matter, the third officer. Yeah, that's the one with the 2 witnesses. Uh-huh. What is the status?
We have been informed that there are 2 witnesses to be presented, and I think those are the last 2 witnesses for the prosecution.
All right. Thank you very much, Senator Richards.
Thank you, Chairman. Just for the understanding of the general public, the 3 individuals are being dealt with separately, and that's and the 80+ meetings that the tribunal has had is separate, 3 separate matters. So about
3 separate
just under 30 meetings each.
Yeah, one was 32 meetings, 123 and 134.
Thank you. Just for my own clarity, you indicated that 2 reports are due on the 9th of December and the 21st of November.
And the 1st of November is the hearing.
The decision on the no case submission.
Right.
Right. So, but you'll get information on that.
May or may not,
depending on
the
what happens.
outcome. Yes.
Is it protocol for the commission now to make judgments on one in the absence of the completion of the others? Or you have to wait for all 3 to be completed?
The commission.
We deal
So you can make judgments.
Yes.
So we will at least get one before the end of the year.
This is what I'm told, that before the end of the year, we should have one coming before us to determine how it's going to be dealt with.
Yeah. I want to direct question now to Mr. Sarah Richards, who is the president of the Prison Officers Association. From the officers who are on suspension perspective, making petitions to you, how would you assess the progress of this from their perspective?
First and foremost, good evening, everyone. I just want to thank you all for the opportunity of inviting us to this special hearing so that we could assess properly Jailbreak 2015 and the aftermath of that. The frustration is enormous because from the start of Jailbreak 2015, there are a number of confusing and misleading information being put, one, in the public domain, and even as far up as this JSC. First and foremost, Jailbreak 2015 took place on July the 24th, after which a sequence of events should have occurred that will lead up to the proper investigating and proper prosecuting, if necessary, of persons who would have, found wanting or who would have accused of committing infractions against good order and discipline, whatever infractions they are. At this JSC, when it was convened sometime in 2016, it was reported that Mr. Dennis Pulchan, the then acting Assistant Commissioner of Prisons, I believe that was the rank then, investigated Jailbreak 2015. That information we want to put on record, Mr. Chairman, is totally incorrect. It was misleading, and it set the tone that we describe as creating malicious prosecution against these 3 officers. Let me correct the record here, take the opportunity to correct the record. And I just will go through some sequence of events. I will start on July 24, 2015. Prison break occurred around 12:30 p.m. That is public knowledge. That is knowledge for the committee as well. On July the 24th, 2015, the acting commissioner of prison at the time, Mr. Ronald Morgan, informed the PS via a memorandum of the prison break that occurred on the 24th, 2015. Mr. Sterling Stewart, the then Commissioner of Prisons, was out of the country. On July the 27th, Mr. Morgan, who acted as commissioner at the time of the jailbreak, handed over duties to acting Commissioner Sterling Stewart with a report of the incident. On July the 28th, Mr. Thomas Espinoza, Assistant Commissioner of Prisons, then he's now retired, was appointed by Mr. Sterling Stewart, acting Commissioner of Prison at the time, to do an inquiry into the prison break. That is what was on July the 28th. On August the 3rd, 2015, Mr. Dennis Pulchan, who I referred to earlier, was appointed by Mr. Sterling Stewart, the then acting Commissioner of Prisons, to investigate allegations against 3 officers arising out of the investigation into Jailbreak 2015. How do we know that there was an investigation into Jailbreak 2015? How do we know that? We know that because the Public Service Commission, in a document to this JSC, said that page 79.1 said, and I just want to read it out. 1, inform of an incident which occurred on July the 24th, 2015, involving the escape of inmates Alan Martin, Christopher Selby, and Hassan Atwell from the Port of Spain prison, which resulted in the death of a police officer, and that an inquiry into the matter revealed that allegations of misconduct against the said 3 officers. So,
you are submitting that there were 2 investigations.
That's absolutely correct.
One by the ASP, what's his name?
Assistant Commissioner.
Assistant Commissioner.
Mr. Thomas Espinoza.
Mr. Espinoza, under the regulations and into the...
He did the inquiry into Jailbreak 2015.
Into Jailbreak July 24th. And then, subsequently, Mr. Dennis Pulchan was appointed by the Commissioner to conduct an investigation into allegations against certain officers arising out of the same incident.
Yes.
And therefore, you are contending there were 2 or parallel investigations.
What was strange, Mr. Chair, that when you asked the question on that said JSC, you asked Mr. Sterling Stewart, you told him that an incident happened that caused mayhem in Port of Spain, that caused panic. You described it in that way. And you went on to ask what happened, what action he took. And he went on to tell you that an inquiry was conducted, and that inquiry was headed by Mr. Dennis Pulchan, was done by Mr. Dennis Pulchan. We are saying for the record, that was a misleading statement.
Okay. So now that you have made that clear, and for the record, let me ask, what is the nexus between that and where we are with those disciplinary proceedings? Are you saying that has had some adverse effect on the disciplinary proceedings that we are looking into today?
Absolutely.
In what way?
Right. If you allow me to continue, Mr. Chair.
1 second, Mr.
And because we will add to, if you could just also, Mr. Richards, give us a sense of, because you're now indicating there are 2 separate inquiries at that point.
Not inquiries.
Well, investigations.
That's correct.
Right. Was the investigation into the actual jailbreak and reporting that completed by Mr. Espinoza?
What is peculiar, and to answer that question, what is peculiar? Yes, the report was completed, right? Because Mr. Thomas Espinoza, in a sworn affidavit to the High Court, right, when information was being sought by one of the officers under the FOIA, because you would appreciate they were attending a tribunal and they were asking for disclosure, and they were unable to get particular disclosure on the matter, which would have assisted them in defending themselves.
Well, I'm asking that question for that specific reason, because if there's an investigation into Jailbreak 2015, and that investigation produces a report, I'm presuming that the report will be the genesis of the allegations for the inquiry that Mr. Pulchan after. Would that be correct?
That is correct.
Would the report, would the officers in question and the association been privy to that report?
No. And as a matter of fact, to even compound that, no one to date can properly account at all for the whereabouts of that report. Because first, you have...
I don't understand. What does that mean?
It means to say all of the agencies that would have been written to, asking one, who preferred those allegations against those officers, and where is that report, right? Those questions remain unanswered today.
All right. Now, Mr. Richards, I had asked you...
Mr. Chair, could you just excuse 1 second?
Sure.
Thank you, Mr. Chair.
My pleasure. I had asked you to demonstrate for the benefit of our committee how, if and how did that bifurcation of investigations, one by Mr. Espinoza and the other into allegations against certain officers by Mr. Pulchan, I was asking you for the benefit of this committee, if and to what extent that has adversely affected the disciplinary proceedings against the 3 officers that we had been earlier told about.
I understand that. When you look at the report, officers were suspended pending allegations arising out of the said report, so said the Public Service Commission to the JSC.
Which report? Mr. Espinoza's report?
Espinoza's report.
Yes.
Right? That no one has. That no one can find.
Just a second. Yeah.
Right? When you look at when that report was completed,
yes,
that report was completed on the 10th of
August.
August.
Excuse me, members of this House, let's listen to Mr. Richards, please.
That report was submitted to the Commissioner on the 10th of August 2015. The action that was taken, the suspension pending investigation into allegation arising out of the incident, where the Service Commission told the JSC, arose out of that report.
Which report, Mr. Pulchan?
Mr. Espinoza.
Let's call one Espinoza report and let's call the other one Pulchan.
Mr. Espinoza's report.
Right.
That action of suspension on allegation took place before, 7 days before, because that suspension, pending investigation into allegations, that's supposed to come from Mr. Espinoza's report, came on the 3rd. That is what the Commission said. The Commission said that the inquiry into the matter revealed that allegations of misconduct. So if the Commission is saying that, it means that the Commission is saying that Mr. Espinoza's report formed the basis of the allegations. That is what the Commission is saying.
All right,
But Mr. Espinoza's report came after those actions were taken.
All right.
7 days after.
All right, hold on. Let me, for the benefit of this committee and the public, remind us of an important fact. It is that the Prison Service Commission is governed...
Public Service Commission.
The Public Service Commission governs the operations of the prison service. And the Public Service Commission's Chapter 101 carries all of these regulations. Regulation 91 says that the commissioner is required to, 1, report the matter to the DPA, the Director of Personnel Administration, for the Public Service Commission's attention. And 2, concurrently warn the officer, whoever might have been implicated in that report, in writing of the report or allegation of indiscipline or misconduct. Regulation 90 further requires that an investigating officer be appointed by the DPA from the Public Service Investigations Unit to investigate the report or allegation. It also requires, there's Regulation 90, that an investigating officer may also be appointed by the Commissioner of Prisons, to which the officer is assigned, and shall hold an office in a grade higher than that of the officer who is being investigated or who might be implicated. And thirdly, the investigating officer should forward to the DPA no later than 30 days from the date of his appointment an investigating officer's report for the information of the commission consisting of the original statements and all relevant documents together with his own report on the particular act. I have just read what the regulation requires. Let me inquire of the Service Commission now, based on what you have just said. You have just said that there were 2 investigations, one by Mr. Espinoza into the prison break, and the other one by Mr. Pulchan into allegations against persons who were involved in that incident. You further said that the Public Service Commission appeared to have acted by suspending the officers on the basis of, I'm sorry, what did you say? What did you say? Tell me, what did you say? Just for correction. For correction.
I said that the commissioner would have acted, right, following the investigative report, right? But such action taken by the commissioner to suspend on allegations arising out of the investigation was taken, that action was taken on the 3rd, and the investigative report was submitted on the 10th, 7 days after.
That which Mr. Richards has just submitted. He sought, as requested by the chairman, to demonstrate a link between what he has said and adverse implications for the disciplinary proceedings as they now ensue. I shared with us element of the regulations. What say you in relation to that?
Chair, I think we have to be mindful too that this is a live matter. What it is we are ventilating here could speak to where the process could have been, I don't want to say flawed, but the process could have been jeopardized if it is what it is he's saying. I think a matter.
I appreciate your point, and I take it with great heart. What I was asking more specifically, though, because one of the things that I think I heard was that the commissioner suspended the officers. I wanted to know from the Service Commission, for the benefit of the public who has an interest in this, whether it is the commissioner's responsibility to suspend or whether it is that of the commission. I just wanted to clarify.
If I may, Mr. Chairman, the Commissioner of Police has delegated powers, of prisons, sorry, has delegated powers to suspend an officer in accordance with the Delegation Act.
That the suspension of the 3 officers by the prisons commissioner would have been in accordance with the regulations.
Yes, yes, Mr.
Good.
Chairman.
He's further saying, and I understand the point that Mr. Harrison made, bearing it in mind, he's further saying that that suspension by the commissioner preceded the receipt by him
Of Mr. Espinoza's
of
report.
Mr. Espinoza's report on the incident. From your records, would that be a true statement or not? That's all I'm asking. From your records, if you don't have them, the prison commissioner will tell us. But I'm asking specifically whether from your records it appears as though these officers were suspended by the commissioner prior to him receiving Mr. Espinoza's report. Does your record speak to that? Yes or no? And if so, is it true? If you don't have that on your record, let me know. I'll give you a little time to peruse them.
We don't have that on our records. We can't speak to that.
So the Service Commission and the DPA are not today able to say with certainty whether the commissioner who had the delegated authority would have suspended these officers before he received Mr. Espinoza's report. You are not in a position to respond to that.
No, Chair, we can't say that today.
Okay, in which case that's a question we would want answered either by you, if you can peruse records at another stage, or by the Commissioner of Prisons. But that, Madam Clerk, for the record, we would like to know. Okay? Mr. Richards, your suggestion is noted, but we are unable to, as a committee, clarify that issue today. Bearing in mind that Mr. Harrison has raised the point that the matters are still live matters, and therefore these public discussions on them ought to take that fact seriously into account. So, for my part, we can await a response from either the Service Commission when it has an opportunity to peruse its records, or from the Commissioner of Prisons. But according to my Jamaican colloquialism, friend in colloquialism, either or either way, we will get an answer to your suggestion. Is that fair enough?
I take it
on
as
that
yes,
score.
Mr. Chair.
May you continue your submission, bearing in mind what Mr. Harrison had to say. If I think we are getting a little exposed in that regard, then I should promptly say so. Please.
Well, Mr. Chair. Mr. Chair.
Because we are here primarily today to look at the disciplinary proceedings and the failure to have them resolved as at today.
And we are speaking to the impediments that would have
Yes.
caused the process to
So
be
we are
undermined.
quite prepared to hear that,
Right.
subject to Mr. Harrison's
That's correct.
submission.
We have no intention on the side of the Prison Officers Association to go into the matter of the tribunal or excerpts of the matter of the tribunal. We are just expressing our concerns, right, on the basis of the misinformation. And I just want to continue, Mr. Chair. On June the 5th, 2017, a letter was written to the Commissioner of Prisons, that is Mr. Gerard Wilson, right? He is currently occupying that position, under the FOIA requesting the name of the person who made the allegations, right? And of course, a copy of the report. The Commissioner of Prisons after we have been seeking that answer, the High Court got involved. The High Court got involved under Justice Honeywell to determine who made those allegations of misconduct against those officers. On December the 12th, 2017, the Commissioner of Prisons, Mr. Gerard Wilson, responded to the FOIA stating that Mr. Thomas Espinoza conducted the inquiry into Jailbreak 2015, which is just as we suspected. And just as we are saying the JSC was misinformed to believe it was one Mr. Dennis Polchan conducted such an inquiry, and we are seeking to correct the records and so on. On the 24th of January 2018, the judgment was delivered by Justice Honeywell stating there is no accuser. Why that happened? You would appreciate during the matter, Mr. Thomas Espinoza submitted an affidavit to the court. And in that affidavit, two things were very clear. One, his report into Jailbreak 2015 was delivered to the Commissioner of Prisons on the 10th of August at 5 p.m. That is when his report was delivered, in the report on Jailbreak 2015. And we know action was taken on 3 officers on the 3rd, 7 days before that period that he's stating. And that led Justice Honeywell to, in her judgment, to say he could not have been the accuser. Right? So that was the judgment. The judgment is that Mr. Thomas Espinoza could not have been the accuser in that matter. Meaning the report submitted by him could not have been used to determine the way forward with Jailbreak 2015 in terms of developing accusations and so on, allegations and so on, for Mr. Dennis Polchan to now investigate. So we are in a situation where no one knows where that investigative report is. No one knows who accused those officers, because if it wasn't Mr. Thomas Espinoza, then who? Because those charges laid against one Mr. Lancelot Dunton, Mr. Wilbert Lovell, and Mr. Mervyn Pierre seem to be very detailed. And our question is, a matter is now being heard at the Public Service Commission level, and in terms of process, all of these questions remain unanswered.
We must await answers. So that is your proposition, that is your position, and I respect that. But for the time being, this committee will inquire of both the Service Commission and the Commission of Prisons as to the report mentioned in Section 90, one of the regulations, and if and when it got to them, and we will take it from there after. So for the time being, on that matter, I think we can go a little further on that particular matter.
Mr. Chair, if I may,
Yes.
I just want to point out to this committee
Yes.
that inscribed into the parliamentary records of Trinidad and Tobago is some erroneous and misleading information that the Prison Officers Association will ask to be corrected.
Take evidence on this committee. We are hard-pressed, if you like, to verify every word, every sentence that has been put to us. We have a particular mandate. Prison security, its policy, national security. So while inaccuracies might be stated in the parliament...
We don't see it as inaccuracies, Mr.
Just a
Chair.
moment, let me make my submission. While inaccuracies, alleged inaccuracies may be stated even by parliamentarians, that is not unusual to us.
Well,
However, our concern today, this committee's concern today, as an aspect of the smooth operation of national security as it relates to the prison service, is the fact that 3 of your personnel were suspended from duty arising out of an incident on July the 24th, 2015. Member Hussein, I'm coming to you promptly. And a disciplinary proceeding ensued. That disciplinary proceeding is, as at today, incomplete. Our concern as a committee was to find out why and to urge and to use whatever power is available to us, its resolution. Now, you, as representative voice of the prison officers concerned, have been in the public domain ad nauseum, and we respect that. On that basis, and because of your genuine concern as the voice of the officers, we asked you to be here today, and you have kindly come. And you have stated your concerns about inaccuracies on the record, which we take note of. But it is not with us to correct it. We don't have Mr. Stewart or Mr. Morgan or anyone here today to put it to them for them to correct it. So we record that. But we are going past that. I had asked, and I'm waiting to hear if you have any further submissions as to whether the concerns you as a representative voice has any effect or impact on the failure of the commission to complete those investigations. That's where it's at for us at this time. Let me entertain Member Hussein. You have a question.
Thank you very much, Chair. To members of the Public Service Commission, you did mention that there's one case where we didn't really have a fix or a set deadline for completion. That is the case that deals with the 2 outstanding witnesses that still has to testify before the tribunal. Can you indicate whether or not there's any case management in terms of when these witnesses will appear, how many days it will take, and when a decision might be pertinent in this matter?
Well, I'll attempt to, and then maybe you would not believe that we do have case management procedures. But of course, there are no sanctions in place. It's not enshrined in the law, and therefore it is very challenging. So although they start off the very first meeting, they follow a case management procedure, doesn't always stick to what they plan for reasons that I gave earlier. So in that regard, I don't have any answer. All I was told is that they're making every effort to have that concluded, hopefully in the first quarter of the new year.
First quarter. Also, with respect to these 3 separate matters, because you did indicate all 3 matters are being heard separately, are they before 3 different chairmen, or is it that all are being heard?
All are being heard by one chairman.
One chairman? Yeah. So the matters are not consolidated, but they're being heard?
No, they are separate.
Separate?
They're each separate, so we'll get separate reports for each particular case.
Would you be obliged to let us, I saw one of the submissions that you made that the persons who sit on the tribunals are on contract employment for a period of 3 years.
Part-time personnel.
For a period of 3 years.
For a period of 3 years. Is it 3 years? In the first
3 years.
instance, yeah.
Chairman, I don't know if you may allow this question, but can the committee find out what would be the remuneration package for these persons?
Well, yes, it is a very sore point with me, actually, with us, with the commission. And thank you for asking that question. The part-time, the members get what it is, like 7. Martin, you want to say about 7 something?
Yes, the member gets a salary of $7,900 with a transport allowance of $1,100, and the co-chairman gets a salary of $13,400 with a similar transport allowance of $1,100. Yeah.
What makes you so happy?
Because the number of cases, if we want to, actually, at this point, we have done a cost-benefit analysis. Because of the number of cases, it is part-time. We really do need full-time panels, tribunals, operating within the commission. And we have done a cost-benefit analysis. We have agreed that 5-member panels full-time, at least 2 in the first instance, but of course we'll try to see how we can transition from part-time to full-time. And it has to go to cabinet for approval. But if we do have full-time, you would see a significant shortening of the time spent in handling disciplinary matters and a consequential reduction in cost to the state. When it's 3 members, if somebody falls ill, you have to, and they're not there, we have to go and start de novo again.
You are saying that the current arrangements, as Member Hussein examined a moment ago, are inadequate to cope with the number of matters you have before you for disciplinary resolution.
That's correct.
And you are also saying, excuse me, I'm terribly sorry. You are also saying that you now are formulating some improved procedure.
We have already done the exercise. We're at the point where a note is going to be prepared for cabinet's approval, and we hope it would be given some consideration.
How soon is that note likely to be dispatched to the cabinet?
Well, we're hoping, before the end of the year, but in time for mid-year review.
Why does it have to take so long, given that you have already recognized that there's a clear problem and you have resolved a solution to it?
Because the report on the cost benefit came to us. So we had a meeting, we gave instructions for the note to cabinet. It hasn't as yet come to us. We're already in the mid-November by the time it comes to us, and so that's why I'm saying by the
Well, if those very hard-working people in your department spend the next 48 hours, it can come to cabinet next week.
I agree with you, sir, especially to what it's
because of the
2010 salaries.
Well, this committee, therefore,
2000?
This committee, therefore, in light of the situation as you have described it and as we have discerned, we urge that we don't wait until the end of the year to get the cabinet involved.
I agree with you, so please take note.
Yes, they can put to work now, and within 48 hours a notice, just start a few pages and get it before the cabinet. Okay?
Is there any other question?
Yes.
Mr. Hussein?
Madam Chair, you indicated as at May 25th, 2018, there were 179 disciplinary matters against the prisons, 42 fire, 223 public. Can you give us the updated figures for the amount of disciplinary matters before the various tribunals?
I have 14 matters before the various, dealing with Public Service Commission.
43?
43. This is what I see here.
So it reduced from 223 to 43?
No, we are talking about, Martin, you want to answer that? That's teaching and...
Where's my own?
Sorry, yes. We will have to provide the committee with the full figures because we don't have, that figure you saw would have been for, the 4 tribunals deals with matters for teaching service, civil, prison, and fire. So that figure that you would have called there would have been for all 4 services.
For tribunals.
Yes. So what Mrs. Manchuk has said is that the 40 odd matters are those that currently are there for civil. Yes. And those are the matters that are currently ongoing. Yeah, those are matters that are ongoing.
Okay. The officers that are currently before the tribunal, they are suspended with full pay or half pay? On what terms have they been? Half salary. Madam Chairman, besides the unavailability of defense counsels at certain instances, what are some of the other challenges that the Commission, in particular the disciplinary tribunals, face with respect to these matters? You indicated 1, unavailability of counsel, 2, the part-time setup. Are there any other challenges that you all face in terms of resources?
Yeah, illness.
Do they have this?
Due to illness, frequently proceedings have to restart sometimes.
De novo proceedings?
De novo. Awaiting legal advice with respect to requests for amendments of disciplinary charges, clarification of regulations. These are some of the things the
do you all have legal counsel to assist these tribunals?
But it's headed by a legal person.
But, understandably, but...
But invariably, the
Legal Unit and Service Commission doesn't interfere in the tribunals just because we are supposed to be impartial and we advise the commissions. So we don't want to involve ourselves at the tribunal stage for fear of prejudice or any likelihood of bias. So we stay impartial with regard to tribunal matters.
The reason I ask the question is, Chair, if you would allow me, in the setup of the judiciary, judges and some magistrates are now afforded staff in terms of research so that it gets matters moving quicker. So I was asking if you are having problems with simple things like amendments to disciplinary charges, whether or not you will have persons assisting the tribunal so that these things can happen in a day or even a few minutes instead of taking long adjournments to come back with these charges.
There are some proposals here which you can fill out.
Okay.
Sure. Thank you. Good afternoon again, members. Let me ask this question. At what point, and this is in relation to the officers that are suspended, does it happen that justice has been seen to be withheld? They are suspended for about 4 years now, and notwithstanding the administrative issues that the Public Service Commission is indicating they have, I am wondering, should the outcome be in their favor, given all that has been said today, what redress does these officers have?
Well, as it regards to the Prison Officers Association, we believe that the officers are the subject in our view, humble view. They are being prosecuted maliciously because the antecedents to those to form the basis for prosecution is still in question. There are still key questions to be answered. So those officers are vilified in the public domain. The extent to which their families have been brought to shame, they have been brought to shame. They have suffered immensely.
This is what he was asking. The lawyers and the courts are familiar with losses that are caused as a result of defamation, various torts, negligence, and all of that. The court has been able to deal with those matters, but that's very general. He was asking a more specific question for the benefit of this committee and the public. Assuming that at the end of the road, the officers are relieved of the detriment that they now face by virtue of being suspended from duty and having these allegations formally established against them. If they succeed against them, like the no-case submission is upheld, what legal, is it legal or what redress is available to those officers? I think that's a question the Commission should attempt to tell us, because you may have had some experiences along that line in the past.
Mr. Chair, if I may.
Yes? You are from
the Prison Officers Association.
Let me give the Commission an opportunity to respond first. He has legal redress. What happens if a person is put on disciplinary charges? It goes through the process in the public service regulations. What happens thereafter if he prevails?
If he prevails, his one-half salary that was taken from him is restored. Retroactively, yeah, it depends.
So he's given a lump sum.
It depends on the decision of the Commission, the nature of the thing. We have had instances where we don't give back all, depending on the nature. So we would take part of it and give part, or it could be restored. If they are innocent, they get back everything. They get back their promotion, you know. Indeed, in one case, we actually got promotion.
Bearing in mind that what we are dealing with here is the regime of public service regulations as distinct from open court.
Yes, so we follow the regulations, and when we decide,
yes,
if he's exonerated, there's no.
Thank you very warmly. Yes, sir, should recognize you now.
Yes, well, let me give you a practical experience, because a lot of officers who would have been on suspension would come to the association with their issues. First of all, when they win their matter, they will await a document from the Service Commission indicating that the suspension has been lifted. This often takes upwards, sometimes up to a year.
We are dealing with what appears, if that be true, to be an aspect of general inefficiency. If it is true that a letter lifting a suspension could take more than a year, so the first question this committee asks is, from your knowledge, from your records, is it true that it can take so long?
Once we take our decision, we expect that the Service Commission Department and the Director of Personnel Administration will do what they're supposed to do in the most expeditious manner.
And I want the public to understand why I must now ask the DPA, because the Service Commission is a constitutional body populated by persons like your good self who has certain constitutional responsibilities. But the administrative aspect of your operation, the secretariat, like we have the secretariat supporting this committee, it is the Office of the Director of Public Administration. And therefore, you will give a mandate that the proceedings are at an end and the officer or officers are exonerated, and you will expect the administrative arm, the DPA, to carry out that instruction with promptitude. So now I must ask the DPA, do you know within your, how long have you been in the department? Let me ask for the bona fides.
Approximately 11 months.
In the office of the DPA?
Yes.
All right, well, you will have, no, that's nothing new. That's nothing new. The records have been there since 1962. Fair enough?
Fair enough.
And you would have perused those records.
Fair enough.
Is it within your knowledge that a letter lifting a suspension could take, as the officer, what name? as
Mr.
Mr. Walcott has submitted before us today, could take as much as a year in real terms? Might that be true?
We have to sort of quantify the answer for that. What it is, we have different tiers or different levels where it is persons may have been suspended. If the matter is a court matter, the court documents may take a while to reach the department to verify whether or not this person has been exonerated or something to that effect. Also, when it is we have to, the matter before it reaches the commission, it would have to get the tribunal's report. So there is give and take some administrative thing before the matter reaches the commission, before the matter has to leave the commission, leave the department to sort of give the exoneration or lift the suspension.
Chair, if I may, please.
All that considered, that this is from the date that the man's matter was completed and he was exonerated for any reason, it could be that it could take upwards of a year to issue the letter of suspension for the reasons you have stated. Is that true?
It's not supposed to take upward of a year.
But it can, based on what you have said.
There have instances where it have taken.
All right, thank you very kindly. Mr. Walcott.
Yes, I was going to give a practical example. Our officer was suspended for vehicle manslaughter. He won his matter in 2017. His suspension was lifted. Yes, yes. His matter was determined January 2017. Documents were submitted, and only with the intervention of the association in 2019, his suspension was lifted after 2+ years of his matter being completed.
Important discussion, treat that submission as a fact. I have no reason to doubt Mr. Walcott's submission before us in the public glare here. So, 2 years after a court matter is resolved, and the association had to get involved, and then the letter lifting the suspension, and the public must understand, the man is charged by the police, he goes through the whole process in the open court, and because of the fact that he's a prison officer, the Service Commission has jurisdiction over him, so they suspend him from duty. They are notified by the court in January of 2017 that the matter is at an end. 2 years later, the letter of suspension is lifted. What say you, Mr. Harrison? Let us assume that to be a fact. How could you explain that?
That is a bit unexplainable, but the factors that may contribute to that may be that the department is awaiting the documents from the court itself. From the court, you see, we have to do due diligence on the matter as well. Our due diligence would not be necessarily information. We would have to ask for court extracts or something specific to the magistrate courts.
Stating that the matter is at an end.
Chair,
Just a second, please, Senator. 1 second. I mean, the reason why I'm pressing this matter is, in Trinidad, what Mr. Walcott is saying is very possible, you know. And worse, you know. We know that. What we are trying to do is to cause all of us to focus a little more deeply on this and to ensure that that cannot happen. Doesn't happen because, as Mr. Richards said, when a man is suspended, a lot hangs on him, you know, bears heavily on his shoulders. And if he's exonerated, he wants it to be lifted, and lifted swiftly. To wait 2 years, and it does affect promotion, it affects a whole lot of stuff. It really cannot be. So the best we could say is to urge you, and we'll come back to a little matter here that would make you more efficient, the cabinet note that we are expecting for the cabinet to consider, to make the thing so efficient that there'll be no unreasonable delay in all of these administrative matters to create further burden and stress where it does not or ought not to arise. That's all we can say. Just a moment.
The Chair, I want to add, we have been actively putting things in place to ensure that that
All right, just a second. Thank you very much. Let me first take Mr. De Freitas and then immediately thereafter you. Mr. De
No,
Freitas.
I just wanted to further on to the first question I'd asked. It seems as though there's a possibility that a particular individual in the employ of the public service, whether it's prisons or whatnot, may find themselves at the tail end of a case, open court. Is there a situation where an individual finding himself in that problem would also have a separate investigation under the Public Service Commission for any breaches in their procedure? And if so, how does the ending of the case in the open court affect that case in the public service? And you could apply to the very specific thing that we're talking about now in the prison break, because I assume there must have been some case in the court, and I don't know if it's done. There's none at all whatsoever.
Senator De Freitas, Saran. Senator De Freitas, I'm glad you raised that point, Mr. Chair. We have several cases. Now, this first to begin, prison break, and I want to state that clearly, was never investigated by the police. It was never a police matter. Need to put that on the record. Secondly, we have officers who have been charged for offenses, went before the open court, won the matter in the open court. When the court extract Read Service Commission, they are now charged under public service regulations for the same matter that they won in the open court. So that's a challenge that we are facing. We have several of that matters ongoing right now.
I take your point. This committee, recognizing some of the facts that are in the public domain, some of which we have traversed already in this committee, we are unable to accept as fact that there has been no police investigation into this matter where a policeman lost his life outside of the Braid jail. So while you assert it as a fact, we will not be able to accept that as a fact. As a matter of fact, I think I heard differently from the Commissioner of Police, but that is to be verified another time, but we will not accept that as a fact. Mr. Lee Hunt?
Just following up on the statement that you were making about, and the revelation of the possibility of that 2-year position, possibility. And one, I just want to find out what if, because we kind of have to decide that that is not acceptable. And therefore, what is not measured, it is not done. So do we have a system, Ms. Manchak, in your reporting that you keep a handle as the Public Service Commission on exactly how long these things via a report that comes to you? And could we, if we don't, start getting that report going? And do we have any matters like that now, if I draw the line today? Do we have any matters like that that are outstanding where a man has been exonerated and we have now waiting 2 years? And finally, could we set a benchmark, a standard, that you, the chairman, the commission, set a standard? This matter must be resolved in 3 months. And if there is anything beyond 3 months, that we make sure that the public personal administration is on it to make it happen. So I'm just putting in measures, and do we have something like that in place?
Minister Lee Hunt, your mantra, what you just said, is our mantra. What is not measured does not get done. And that is the issue of supervising and managing officers in the public service is a big issue in terms of productivity. And we have instituted something here from captain to cook is getting measured. And in particular, with respect to these disciplinary matters, we have had a presentation before us just last month. And indeed, we have benchmarks, and they have to follow and improve on their productivity in that area. So it is something that we have looked at, and it is going to be followed more and scrutinized more closely.
All right. And
Okay,
yeah, so again, yes, so we could, at this point, I don't know if it needs a feedback or anything like that, know that there are, based on the fact that it's being followed up, that there are no other matter like that that is in the pipeline, so that we know that this is something now. It has brought up, we recognize us wrong. It is not going to happen again in the public service, because we now have a standard and a disciplinary measure. If that is happening, somebody head is going to roll for it.
Chair, I just wanted to address the question by the member De Freitas with regard to matters that could possibly be before the court, and that is provided for. Let me just give a little background. Disciplinary matters really arise out of offenses or allegations of misconduct. Now, there is something called a code of conduct which defines what misconduct is. So what the commissions do is they look and see whether the officer has done an act against the code of conduct. That's how discipline works in the public service. So if an officer does a criminal act, it could also fall within an act of discipline. So it could be an act of misconduct, and it can be a criminal act, and it can be dealt with by both jurisdictions. In some cases, for example, and I'll just give an example, murder, that cannot be dealt with under an offense of misconduct. That is a criminal offense. In those cases, what the commissions do is they await the outcome of the criminal matter, and then there's a section in the Constitution where we can look at the proceedings of the criminal matter and impose a penalty based on what happens at the criminal.
And what about, as you just used murder as the example, what about actions or the negligence thereof that lead to death, much like in this case here?
Once it can fall under the code of conduct, once it falls, you have to look at the circumstances and see whether there's a nexus between what is in the code of conduct and what are the offenses outlined in the code of conduct, as opposed to the criminal conduct itself.
The number of matters that are within your purview that have already been exonerated, either the criminal courts or your regulatory apparatus, the dates that the exonerations or the completion came, and this is in furtherance of what Mr. Leant has so properly brought to our attention, and that is as at today. Today, the 13th, is it? Yes. Which matters you have in your briefs, in your purview, that have already been treated with in the court, where you have noticed that they have come to an end, exonerating the officers, and of course in your disciplinary tribunals, where there have been exonerations, and the status of those, insofar as the letters removing the suspensions and, for the redress, the back pay and restoring their normal terms and conditions of work and service. So we look forward to that. But how soon do you think we can reasonably expect that?
On a point of clarification, Chair, how far back?
We're talking about as at today.
Yes, but from...
Well, I don't expect you will have any 5 years back.
If it's from, no, I mean, if... You're saying how much matters as at today, persons will
as at today, the 13th of November.
Yeah.
So whatever you have, I don't expect that I'll see any from 2010
That those happen.
May I thank you? How soon, therefore, can this committee look forward to that report?
It will take 1 month's time.
Should we say 21 days?
21 days.
Thank you very kindly, Madam Clerk. We'll anticipate that in 21 days, and we thank you very warmly. Mr. Walcott.
I wish to thank you, Mr. Chair, because as officers' representatives, we see the pains of officers, because not only do they have to wait on the suspension to be lifted, they also have to wait months to get salaries regularized, because they'll have to audit. So they go through a period of hardship before they are regularized. And this also pains us as an association to see our members continue with the suffering.
Well, we understand that, but we know that you are a very well-resourced association and you care for your members, so you would apply a number of palliatives in the circumstances. And let me not say more.
Just one more thing.
Let me not say more.
That is why, as an association, we look at prison break with such concern, because when we have members, because this is 3 members' lives we're looking at here. So we, as an association, looking at the process to make sure that the process was done properly.
Yeah, we understand
before
that.
the administration of justice.
We understand that.
So that is why the importance of understanding what took place in the broader investigation.
Well, I might inform you, our mandate, as I would have said at least on 3 occasions today, has to do with prison security generally. And next week, this committee will be getting deeper into the facts of the matter. Because while you're concerned about your officers, we, on behalf of the public of Trinidad and Tobago, we're concerned about your officers, the life of that police officer, the fact that arms and ammunition got into the jail and were used to escape out. We are concerned about the shooting that took place on the compound of the Port of Spain General Hospital, endangering other citizens. We are concerned about a whole panoply of facts. And we will get into that in due time, because this committee wants to tell the larger parliament what happened. Police would be before us, everybody would be before us. And we want to give the parliament the assurance, and the people by extension, that that will not, or is at the least, very unlikely to happen again. And I know as an association, you too would be concerned about those larger issues rather than the working conditions of your 3 members exclusively. So we'll work together through this.
Mr. Chair,
Let me say this. Let me say this. We received a letter from the Service Commission's Department, DPA, which was dated the 13th of June, 2018. And in this letter, at page 3-4, do you have that letter before you in your records, or you would like a copy for ease of reference? Yeah. At the end of page 3, the DPA is saying to us, highlighting some recommendations on how the Public Service Commission's disciplinary system and processes may be improved, something that is very critical to all of us. It lists on page 4 7 points. 1, the chairman of the tribunals, and there are 4 of them, should have the powers to mandate the attendance of attorneys when dates are fixed for proceedings, since proceedings are hampered when attorneys have to attend other court matters which take precedence over tribunal hearings. And you did allude to that earlier when you said you are last in the chain, lowest on the feeding chain. That is to say, these lawyers who represent persons in the society, including persons before you on disciplinary matters, they give precedence to High Court and Court of Appeal and Magistrates Court, and the last of the Mohicans is the tribunals there. So very often it is the absence of the lawyers there that impedes the work of the tribunal. Is that correct? I don't know how you will mandate that they come when dates are fixed, because in the generality, we are now establishing, the country is now establishing a state public defender system. Because the legal aid system now, which allows persons to get free access to legal aid, the lawyers in the legal aid system suffer the same problems and behave the same ways. But with the public defenders now, when the prisoner says to the court, the accused, my lawyer is not here, then the state can say, look, we have a very qualified, paid monthly lawyer to make sure you are in good hands. This matter will proceed. But I don't know how you will achieve that. Maybe we may have to link it to the public defender system for the officers of the public service who come before you. The second recommendation that you are making here is that CAT reporters, computer-aided transcription, which is the full version of the abbreviation CAT. CAT reporters, transcription specialists to take notes of evidence. Is it that right now it's that was a problem existed in the courts before, and in the other courts, open courts, they are moving towards CAT and even voice recordings now. Huh? Right, so I would like to know, what progress have you made in relation to bringing CAT reporters into the process? Any progress so far?
Well, what it is we have attempted to do is start using recordings. The issue of CAT reporters and transcription specialists is one we also have to factor in a cost. And at the moment, we can't afford that. So we have started using the recorders as a pilot project, so persons are not utilizing the writing anymore. It's a recorder, a normal recorder, and then they transcribe after. Yes.
Letter dated the 13th of June 18, no real progress has been made in terms of training or getting CAT reporters into the system.
No effort has been, well, we have been trying, but I can't say we have bear any fruit as yet.
Because what we are looking for is an improvement in the tribunal process. And the DPA is saying that this is one of the measures. So I'm now asking, Madam Chair, would we expect that this form part of the Cabinet's consideration?
It could.
Thank you very warmly. It must. It should.
It might take a little longer for the Cabinet note because now we're introducing new staff, probably staff on the establishment. It could be contract staff. We have to get. So we can't
rather than 48 hours,
if you give
we're
us
not inventing the wheel here. Rather than 48 hours, it could probably be done in 72.
How about 96?
Yes. We then have the third recommendation, case management staff. The Public Service Commission has mandated the tribunals to use the case management approach and has provided guidelines so to do. The assistance of the case management officer assigned to the Police Service Commission will be sought to provide guidance to the discipline unit. So I'm now asking, in light of this, dated the 13th of June, Mr. DPA, has any advance been made in relation to this particular point? Introducing, training, staffing, liaising with the Police Service Commission for a case management approach, because 179 disciplinary matters, of which about 70 of them is prison officers, I might tell you from my other learning, in wearing another hat, is quite a lot. So have we made any progress in respect of the case management approach? If so, what To what extent?
We have made steps with the case management approach. We have established a case management policy. However, as I think someone mentioned before, we don't have sanctions to ensure that adherence to the case management protocols or the case management dates that have been set up because, as you rightfully know, we are the last on the totem pole concerning. So dates would have been set, but we would have adjournments because priority have been given to Court of Appeal, magistrate courts.
Civil proceedings rules from 1998, which regulated the conduct of lawyers and the case management approach in the civil jurisdiction. We have now created criminal procedure rules, which is now part of the law to deal with that. It simply means an updating and a reworking of your regulations to make this part of it. That is a work to be done. So you all may want to consider getting a consultant on board and begin to work because it is necessary and it only mimics that which already exists. Please, Madam Chair.
They are included in our updated regulations. I think it's now with the Attorney General's office.
Okay.
It's been there for some time.
In which case, we will inquire of the Attorney General's office as to the status of this.
Of the
You are certain that it is in the
public
office of the...
service regulations, yes.
You are certain that it is there? Well, we will pay attention to that and we will give you some advice on that. We would like to find out the status of that in the office of the Attorney General. The fourth item here in this letter, dated the 13th of June 2018, regarding the investigations unit, the offices of senior investigating officer and investigating officer were recently advertised with a closing date of the 22nd of June 2018. The question is, have we recruited a...
We have concluded the interviews for both positions. What it is we're having here is that persons are sort of refusing the offer that we put out. So we have to go back to the CPO's office, the Chief Personal's office, to get new terms and conditions.
All right. So in other words, you advertised the position. And the date for submissions was the 22nd of June 2018. And you didn't get any willing suitors.
We got two candidates for the positions. Yes. But when it is we provided our offer, yes, they had concerns with the offer. This is not unknown to
the public. In light of the exigencies of the problem, some salaries or some allowances to bring it up to something that is appreciable, and then you negotiate with the with the CPO. That has been done. No CPO is supposed to sign off on it, but in these circumstances, I've seen in the public service, some interim salary is offered, and then it comes to cabinet, and then the CPO works thereafter. But you cannot not just have these critical office holders. So I want to propose that you open the doors again. Find out from the CPO, discuss it with them, discuss it with your ministry, the public administration, and get to work because you need to have these people. If the offer that you have now in accordance with the CPO's recommendations is not suitable, then you have to do something about it. We can't just sit down.
Chair, we
Yes?
had interviews in May, so we would have made the
Of
offer.
2019?
Yes, we would have made the offer in and around July, August. We had the issue with the salary. I was advised by my HR staff last week that we got initial approval from CPO about last week, but I think it has to go to the Ministry of Public Admin just for that final approval. Once we get that, we should be able to have those persons
But I
on
must
board.
tell you, I must tell you as a citizen with access to you here today, it sounds all like molasses going up a wall, you know. It sounds like a crawl. It sounds like a walk in the park. It doesn't sound like we have some spark and some spunk, and Trinidad and Tobago has to resolve these matters with urgency. It doesn't sound to this committee like that. That's what I want to say on behalf of the committee. It doesn't sound like it has spunk in it. And we understand that we have a bit of a crisis. And we need to resolve it. Because I'll tell you this, and you can't gainsay it, it's the truth. The one thing that is done on time is public servant salaries. It gets done. On time. And if it is one day late, Mr. Saren Richards and his compatriots will be out there shouting, "We want we money now." So I'm
Rightfully
saying,
so, Mr. Chair.
and I'm saying, yes, Mr. Leon?
Yes, and rightly so, and therefore, but the public and all the services that the public is required from, they have a right, and they're doing it through their representatives to say, we want service now, right? We want service now. And therefore, 5 months to solve a problem, all right, is definitely not acceptable, right? And I'm sure Mr. Richards will agree with that. We have to, and a lot of that, yes, there are systems and procedures, but there must be a will to make sure that it happens because of the fact that the same public that is out there is the one, and yours, the same people, the civil servants, are the ones that are affected by the non-performance. So we cannot only have one thing working in the public service, is the fact that people get their salaries every month.
In which case, we would like to suggest that you, in writing, in 21 days, inform this committee what action has been taken to resolve the problem of the appointment of the senior investigating officer and the investigating officer. And I must tell you in advance, I'll be inviting you back here before us, this warm, comfortable company that you enjoy today, shortly thereafter, to tell us. So, Mr. Martel, what's his surname?
Waldron.
Mr. Waldron, whatever you have to do, because you know what to do, you've told us that, could that be done within the next 3 weeks? And we'll expect some feedback from you in 21 days.
Definitely.
Is that okay? Thank you very warmly. The fifth issue was that the fourth disciplinary tribunal, because you have 4 established ones with all of the warts you explained earlier, which we accept and appreciate, but the 4th one would be dedicated exclusively to prison service matters. I think I alluded to the fact that they are greater in number than any other group in the public service, and therefore that is a sensible proposition. Has that been given effect?
Yes, that has been put in place.
So the 4th tribunal, one of the 4, is now exclusively for matters of the prison service.
Yes.
Mr. Saren Richards, that must please you greatly.
Mr. Chair, as the Industrial Relations Officer, I have the responsibility of representing officers at the tribunal. Yeah. And through you, I would really like to hear when this was established and who is the chairman. Because at present, as we speak, I appear before 3 separate tribunals, one chaired by Mrs. Liverpool, one chaired by Mrs. Chandul, and one chaired by a Mr. Welch.
in matters that all began recently, or they might be historic, have some vintage?
In Ms. Chandul's matter, in Ms. Chandul's tribunal and Mr. Wells' tribunal, those are recent matters.
All right, in which case, Madam Chair, having submitted to this committee that one of those tribunals are exclusive to prison matters, I've now heard, which I accept as a fact, that that may not, it doesn't appear to be so. What say you?
This whole idea or decision to have a tribunal dedicated to prison matters is something new, in that we've recently hired, how many? Two members, and we already, three members to have a full tribunal. So that is the tribunal that is going to be dealing with prison matters. I have to, based on the decision, on the meeting here, I will bring that back to the commission because it can be done.
So you are saying, for clarity, that the decision was taken, but it has not yet been actually effected.
Exactly.
Okay, I think that brings a little clarity, and
Yes,
that
so
answers
that
your
is
question.
why you would
Thank
find
you.
them
Thank you
under
very
Welch
much.
and so forth.
Thank you very much. Item 6 was access to the Hewden Law School online library, because as Mr. Saddam Hussein pointed out a while ago, a lot of the matters that you traverse in these tribunals touch and concern, it's public law. It's issues of, similar to what you'll have in a judicial review matter. It's about fairness, it's about laws of natural justice, precedents, and it appears from this that you do not have a very organized and healthy law library at your facility, at your disposal. Am I correct? And therefore you would like online access to the Hewden Law Library.
Correct.
Right. What progress has been made in that regard?
No progress have made with respect to this aspect. This
So that if I ask that in 3 weeks you also tell us what progress, what action, and what progress has been taken to get access to that.
Yes, we can give you some feedback in 3 weeks' time.
Do you have a library at all?
You have a library, right? Yeah.
Let me ask in all seriousness, DPA, do we have a library?
Small law library.
A small law library. All right. Well, clearly, online access is where it's... Terribly sorry, folks. Online access is where it's at. And it's a sensible proposal to get access to the Hewden Library and WebOPAC, which is the High Court's library. And so I would like to hear from you by letter 21 days hence what action have been taken to advance that sensible proposal promised on the 13th of June 2018. Yeah. And finally, thank you very much. Finally, item 7 says, cooperation of and collaboration with the magistracy to provide timely information on the following with respect to public officers who have been charged before the courts. Dates of hearing, certified copies of court extracts, and notes of evidence and court proceedings. So that you are proposing here to make a link with the magistrates' court, where sometimes the officers of the public service are also simultaneously before them, and in some cases exclusively before them, you having only suspended on account of them, and you would like to get some details as to the dates of hearing, certified copies of court extracts, meaning the resolution, and notes of evidence and court proceedings. Those things will help you in making your decisions as to whether to reinstate the officer and to do so in a timely manner. That requires a memorandum of understanding. We've seen this kind of thing happen before. And have you taken any action in that regard so far since June of 2018? Yes?
Yes, Mr. Chairman. well, historically, the department, Service Commission Department, will normally write per case, yes, and ask for extracts and so on. But what we have started recently in more detail is my officers actually go into the court, because we have found that the process to await submissions really takes long. So we actively go to each court and collect, you know, the extracts.
That, of course, is when you are
notes
aware that a public officer is before the court.
Right.
There must be cases where you are not aware that a public officer is before the court.
Yes.
And there?
Yes.
Because some public officers actually hide that fact from the court.
Yes, yes, yes.
How do you treat with those? Well, in fact, such officers you may not need. How do you deal with that?
Yeah, well, once
because if the officer never shares that,
right,
with the head of his department, it never gets to the Service Commission. He's never suspended. If they find out, they may suspend him. But how do you deal with that little?
Ms. Douglas will speak to the regulation.
That is actually an offense under the Code of Conduct if the officer does not report a matter.
Oh, I see.
To his head of department or to the commission. It's actually an act of misconduct as well.
Have you all found that that has happened on occasion and disciplined persons for that?
Yes.
You've had that?
But what normally happens also, Chair, is that if an officer is arrested, normally the police officers will ask the officer where he's employed and so on. So normally we will get a correspondence under the hand of the Commissioner of Police saying Mr. X or Mr. Y has been arrested. Sometimes, for whatever reason, one or two may fall through the crack. And those are the ones who, once the Commission becomes aware, action is taken. But I wanted to also add, based on the 7, is that recently, based on a recommendation of the DPA, a proposal was put to the Commission to establish a policy where persons who are so charged and who may be on suspension to monthly report to their head the regular updates as to their matters and their heads to report to the Commission. So that decision was taken in October. And it will be issued, so it was issued on those matters, but it will be issued to all PSs on head as a policy, so that the Commission will be informed on a more regular basis, the updates. So the issue, hopefully, that Mr. Walcott raised, it will come to the Commission because the onus will be in a point on the officer to inform the ministry regularly as to an update on his or her matter. Yeah.
Thank you. Madam Chair, one of the reasons why we traversed this list is because, obviously, some of these matters should find itself in the cabinet note to the extent that they have to. And we have sought some feedback within 21 days and so on aspects of it, and we really do look forward to some swift responses and action in these matters, make your life a lot easier as a commission. And yes, we have noted that the whole system seems to be a little bit more than ordinary lethargic and unimpressive, uninspiring, actually. Mr. Lehunt may even say hopeless, but he's not that kind of man. But we really need to do something about this, okay? I think we are winding to a conclusion, but before I do that, I must do a couple of things. I must accord you an opportunity and my colleagues to say any parting words. But before I do that, I think it behoves of me. Where is it? I'm looking for the line where. Yes. It behoves of me in the context of an earlier aspect of our deliberations today to bring to your attention. And this is important. I'm not going to dwell on it again because we have sufficiently so dwelled. But I must bring to your attention that in our report to the Parliament that I made reference to earlier, paragraph 2.14 says, and I quote, by written submission to the committee dated, meaning this Joint Select Committee, February 25th, 2016, the Commissioner, meaning the Commissioner of Prisons, advised that investigations into the events surrounding the prison break were conducted and that a comprehensive report was submitted to the DPA, Director of Personnel Administration, by investigating officer ACP Acting Mr. Dennis Pulchan on October the 2nd, 2015, under confidential cover, in accordance with Regulation 90. I state that only for what it is worth. So, in our report to the Parliament, we are reporting that the Commissioner has advised us that a report at the hand of Mr. Pulchan was submitted under confidential cover to the DPA in accordance with Regulation 90. So, I would like to invite
Mr. Chair, if I may, I know you want to move on, but that statement made begs some clarity, because we on this side here, the Prison Officers Association, is not clear on what report you are referring to. Are you referring to...
Members, President, Mr. Richards is on his legs.
Are you referring to report into Jailbreak 2015, or are you referring to a report into the allegations made against officers following an inquiry into Jailbreak 2015? We are very unclear in where you are going and what you have stated.
In light of the previous discussions and the clarity that we seek to answer your earlier question, we still await that feedback, which we expect to get either from the service commissions, their report, their files would reveal that, or alternatively from the Commissioner of Prisons. This committee has already recorded today that we will seek clarification.
And we understand that, Mr. Chair.
Wait, hold on. I simply read for you a paragraph of the previous report of this committee, which says, and I quote again, because for the time being, I just felt obliged to read this into the record today, but it cannot be resolved today, obviously. So let me read it again before we press on. By written submission to this committee, dated February the 25th, 2016, the Commissioner advised us that investigations, didn't say which one, if there were two, he just said investigations, into the events surrounding the prison break were conducted and that a comprehensive report was submitted to the DPA by investigating officer ACP Mr. Dennis Pulchan on October the 2nd, 2015, under confidential cover in accordance with Regulation 90. I might point out, I'm adding now, without more, that it falls within the regulatory power of the Commission to appoint an investigating officer. We will get clarity about these matters going forward. I merely say this in fairness to all parties present today. Obliged. Members, as we wind smoothly and seamlessly to the conclusion of today's proceedings, I invite you, if you have any thoughts, any closing comments, to render.
Based on what I heard, right, I would, and I'm not an expert on the public service rules and regulations, but common sense will tell me that if the commissioner also has the designated powers to make decisions and to suspend someone, it would be foolhardy or negligent for him. He could make that decision based on what is in front of him. I am suspending based on information. I don't need to necessarily get a report before I make the decision within the confines of the information that is in front of me to make a professional decision. Because if I see information that I feel is sufficient for me to make that decision, and I don't act on it, and I am just waiting on a report, I could be acting negligent. So the concept of whether or not I make a decision, and I didn't have a report, or I waited, that I think is really just trying to pull. I think at the end of the day, the commissioner has a responsibility to protect all that is before him, and he has a right to make a decision whether I am waiting on a formal report coming or not. And in the line of management, I have done that on numerous times because of what is before me, because I have to protect the whole organization. I say that and I put it there, and I say that is just my view, just hearing the information and my interpretation of it, because that makes absolute sense. So holding on as to whether or not I make it before I get this report or after I get this report, the commissioner has, I have a responsibility, and I have acted upon it. Right? At that point in time, that will be dealt with. I think also what has come out, and I think the point that is also clear, there's a lot, when I hear about these suggestions and the timing of how long these suggestions are in, I think there is a need for, as I said before, speed, urgency, recognizing that we are here to serve and recognizing that we all get paid at the end of the month, and there is a need for urgency, because we are doing something, we have a service to provide to the public. So I just want to push and continue to encourage, and I hope we get from all agencies that continue to advocate. And in this case, I understand the problems of the members who are without, who are feeling the impact. But I want all of us, and as I whispered to my colleague next door, at the end of the day, we all as a country needs to focus on the need for the public service to get that sense of urgency to deliver. Because the people who benefit or who suffers the consequence when it doesn't happen is really the same general public that we all serve. And that's coming out of that. I am not happy. I'm not happy with the urgency that I am seeing being put onto certain critical matters to make sure that they happen. Every day, that should be our mantra. Push, 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 push. And you know what? If everyone does that, rather than talking, well, I agree, if the ones in the magistracy and every department of the public service start to take that new mantra, then the new society that we're trying to create will eventually evolve or emerge as a result of it. Thanks.
Thank you, Mr. Hussain.
Members, I promise not to be as long as my former colleagues. I want to reiterate the sacred duty that the Commission has to perform in terms of this particular matter. I think it's far too long, enough time has passed to bring some sort of closure to this matter. I think it will bring closure to the general public, to those who are involved and those who have lost their lives in this incident. And I think the Commission has to do all that it can in order to bring Trinidad and Tobago at a better place. Because when you make your determination, this committee now has that information where we can use to craft policy with respect to oversight so that this incident never repeats itself again in our republic. Trinidad and Tobago is going through a very difficult time right now. But I think once we have the support of the public service, who is the largest body of persons who are employed in the country, the government is the largest employer, that once we have some sort of efficiency there, we can bring Trinidad and Tobago to a better place. Thank you very much.
All but 5 minutes less than my time.
Thank you very much.
5 seconds.
Mr. De Freitas?
Thank you. Well, I too will be shorter than both my colleagues before me. I just want to point out some final observations and speak to, as much as we are doing an inquiry into this particular incident, to point out that there have been several other incidents after this, some of which have been quite displayed in the public domain. I think there was one with 2 individuals who were actually sending messages and press releases out. And then the other one prior to that would have been the Vicky Boudram situation. So my question is, has any investigations or are there any cases in front of the Public Service Commission related to those incidents? Because I'm looking for some level of consistency here. We had an incident in 2015, and we're trying to wrap up this inquiry on that, but there have been several other incidents after that, and I haven't heard anything from the Public Service Commission or investigations otherwise, Mr. Chairman.
Well, as I did indicate, we are going to be getting into some substantive issues regarding prison security on our next turn. And we will be hearing from the association, we'll be hearing from the prison administration, we'll be hearing from national security, we'll be hearing from the SSA, we'll be hearing from the police, we'll be hearing from former prison inmates, we'll be hearing from some who would have been escaped and recaptured. We'll be getting the full range of the facts, because we have to take a very intimate and bold look at this matter, because it is very, if I may be permitted, an Americanism, one that I'm uncomfortable with. It is very concerning. I don't know if that's a correct word, but it concerns me greatly as a member of the public, the matters that Mr. De Freitas has just raised. So thank you all very much, members of the committee. And now I would make the floor available for some closing comments from the service commissions, from the DPA, and from the head of the Prison Service Association, Prison Officers Association, Mr. Richards, beginning, of course, with Mr. Richards. Closing comments as we bring this 51st meeting of our Joint Select Committee.
First and foremost, just to clarify for the information of Mr. Lee Hunt, because I took note of the comments he made in his closing submissions. It was not for the Prison Officers Association at that time to examine the powers of the Commissioner of Prison and whether or not, on what circumstances that he would have exercised those powers. We were merely reporting to this committee that the Commissioner reported something that did not happen. That is what we're reporting.
Okay, take
right?
the point.
And what did not happen, which is a fact that can be verified, is that Mr. Dennis Pulchan never investigated Prison Break 2015. He did an investigation, but he did not investigate Jailbreak 2015. So when the Commissioner reported to this committee that he did that in the presence of both Mr. Dennis Pulchan and one Mr. Carlos Craspi, he knew. We said it, we are saying it to this committee, and we want the nation of Trinidad and Tobago to know. He knew he was misleading this committee, and by extension, the nation. We just put that out.
For this, just a moment, in fairness to all, present and absent, this committee can only go as far as to take the submission from the commissioner, from your good self, from anyone else who appears before us, even from members,
and I accept that,
for
Mr.
what
Chair.
it is worth.
And I accept that, Mr. Chair.
This committee is not in a position to say whether somebody knew what they said was correct or otherwise. So we need not detain ourselves with that.
I take your point, Mr. Chair, but just continuing.
Yes. So what we will have on record are statements, and we make of it what it says, and if we need to go further, we can and we will. But for the time being, we are not in a position to say what was operating in the commissioner's mind or in anyone else's mind, including yours.
And I take your point. And I take your point,
Your
Mr.
closing
Chair.
comments, please.
We just want to say, as the Prison Officers Association of Trinidad and Tobago, July the 24th, 2015 is a very significant time, not just for the prison service, but for the country as a whole. July the 24th, the escape of that said day, that fateful day, represent to us the second most significant incident in Port of Spain after July the 27th, 1990. At least in my lifetime, I don't know for you, Mr. Chair, and the other persons around this committee. And we are still disheartened that after such a significant event, traumatizing the country, that we are yet to have, for the information of the public, closure on this matter. And I said the public also encapsulating officers in the prison service, inmates, and everybody involved. So far, we are yet to see any report 4 years after. 4 years after, we are yet to see any report that will tell us, that will educate us as to how the guns and grenades came into the prison domain, what would have facilitated the opportunity for these instruments or these weapons to be used in that daring jailbreak, right? And who are the persons culpable for having those things brought into the prison domain. Until and unless that question is answered, you will have a prison service that is still unsettling, because we could very well have a situation where officers still don't know who to trust. In the absence of that information, the public don't know who to trust in the absence of that information. And one of the things that we want to put forward too is to question, because I heard what you said in relation to a possible police investigation. To date, after 4 years, there is no evidence. I am not saying a police investigation is not on the way. I am not saying it is not happening at this time. I am saying there is no evidence that such an investigation is being pursued at this time. And ultimately, there is no report. So again, if we are to look at July the 27th, 1990 as any indicator as to what to expect, we in the public domain could verily believe that Prison Break 2015, we could look at it as being an incident that could likely be swept under the carpet, because it took over 20-something years, I could recall. I was a teenager at the time of the July the 27th, 1990 coup, and it's only when I entered into my 40s there was any sort of serious investigation into that. And if that is a standard that we are setting as a country, that is a standard that we should not continue. The Prison Officers Association of Trinidad and Tobago will be eternally vigilant so as to ensure that Jailbreak 2015 comes to a close. And when I say a close, I mean all investigation, whether internal prison service and external police service, is concluded, so that we will have a complete appreciation as to what happened in our country at that fateful time, at that day, right? And so that we can move comfortably into the future
Thank
and
you
make
very much.
the appropriate recommendations.
Thank you very much.
We will be vigilant as to ensure that that happens. We will be very restless.
Thank you very much.
Very restless.
Thank you very much.
until that
And of course, I did say on at least 4 occasions during this session, Mr. Richards, that this committee, given our mandate, will be inquiring into the substantive elements of those matters as it affects national security. And that is forthcoming. Yes, DPA?
Chair and committee, we thank you for the opportunity for us to be able to bring some clarity on this matter. It would not be long. We have been putting things in place to ensure that our processes are improving. So the things that were ventilated at this committee, we hope that it would not be ventilated again and would not come to light again. I thank you.
Thank you, too.
Thank you, Mr. Chair. I know this matter of the prison break has been with us since 2015. And for some reason, the Public Service Commission has been stuck with taking long. It's 4 years, and we have not come to a conclusion. But I want to point out that from the moment the officers were interdicted, almost immediately, we got pre-action protocol letters. And of course, that meant that we had to stay the proceedings of the tribunal to await the outcome. And that took more than a year. And then, of course, so really it didn't get off the ground until mid-2018, as I referred to earlier. So we're going to do our best to bring this to a proper conclusion as quickly as possible. The deadlines that we have given you, I am going to push to make sure that they are sustained, and we hope, for the third one, at least by if not by early in the new year. I want to thank you for your support for full-time member tribunals, and we are going to be submitting the note to cabinet within 21 days, as you suggested, taking into consideration. Where is that?
I'm sorry, I did not say 21 days on that. I said 48 hours.
Oh,
with a concession to 72.
Oh, but.
And I only did that based on the fact that this is a matter of long intellectual
bearing in
standing
mind that
and the urgency and the need.
Yes, I recognize the urgency and the need, and we are going to do our best, but we have additions to put into that note, so we're going to do our best to have it as quickly as possible. I want to also say that with respect to service and the urgency to serve, that is what we have been preaching all day. Every meeting, we meet every Tuesday on the need to be more efficient in terms of what we do. And I hope that we will continue to do that. Thank you very much.
I thank you all very much, members of the Police Service Commission, particularly my old Public Service Commission, particularly my old parliamentary colleague and friend, yes, former Senator Mahabir. Thank you all very much, and your staff and support. I would like to thank you, officers of the DPA. I would like to thank you profusely, Mr. Richards, for your very vigorous advocacy on behalf of your officers. It's important to us. And I most particularly like the fact that you do understand that ours is a very sincere effort to resolve some of the problems that afflict Trinidad and Tobago in the realm of national security, and we assure you that we would continue. Thank you all very much, and I would like, therefore, to suspend this sitting to permit the swift departure of our guests, and I now so do. Thank you very warmly. Travel safely.
Mr. DeFreitas. I see.